It was a story that shook the Seattle community and the country. An 80-year-old dog walker murdered in broad daylight in the Madison Valley neighborhood. And despite a very lengthy criminal history, the man charged in her death never hit Washington's three-strike law, putting violent repeat offenders away for life if convicted of 3 so-called most serious offenses. But he could have. So what happened? I went to prosecutors for answers, investigating the case of Jahmed Haynes.
We are tracking breaking news out of Seattle. A woman dead after a brutal carjacking.
A neighborhood dog walker killed.
A dog was found dead in a recycle bin.
Our SWAT team was able to safely make an arrest.
I think about it every day.
This is Melanie Roberts' never-ending nightmare.
I didn't get the chance to say goodbye.
Trying to make sense of the horrific end to her grandmother's life.
She was failed on multiple levels. She was not kept safe.
Waiting and praying for justice. But month after month, getting nothing but disappointment.
Mr. Haynes lacks capacity to stand trial.
The judge won't let us show you the face of the man charged with 80-year-old Ruth Dalton's murder, but his picture has been shared far and wide for decades. Jahmed Haynes, a career criminal having spent nearly half of his 48 years behind bars. Despite 8 prior felony convictions, Haynes never triggered Washington's 3-strike law. But based on court records I dug up, he could have.
He never should have been out on the street. That is maddening to me that all of this was avoidable.
Cairo 7 has been covering Haynes' most egregious crimes since 1993. Haynes, just 16 when he killed someone as he was driving drunk and recklessly in Seattle's Capitol Hill neighborhood. Strike 1, vehicular homicide. Haynes spent the next 6 years in and out of jail, and in 1999, his next strike inside this Renton Safeway. Haynes stuck a semi-automatic pistol into a clerk's side, ordering customers onto the ground. Cairo 7 there again, as Haynes tried to escape police in a stolen car, the chase coming to a crashing end. Strike 2, robbery. And in 2003, the strike that never was, from behind bars, assault with a deadly weapon. Haynes used a 12-inch sharpened metal pole to attack a guard, knocking him to the ground. The guard finally able to kick Haynes and run to a safe, locked space. Haynes then started pacing outside the booth, smiling, weapon still in hand. A mental evaluation from the Department of Social and Health Services after the attack, unveiling a history of mental illnesses while he refused medication. He got 2 90-day stays at Western State. Medication forced, and his mental competency restored, with the doctor leaving 1 bombshell sentence at the end. High risk to commit future violent crime if he stops taking medication, which he stated he intends to discontinue. Despite the DSHS evaluation, Snohomish County prosecutors struck a plea deal, giving him 3 lesser felonies and a second chance on a 3rd strike.
The defendant.
We went to the prosecutor's office Chief of Staff Michael Held. He wasn't involved in the Haynes case, but he can provide insight. Knowing we have somebody who's very mentally unstable, who's saying they likely will be unstable again in the future, but we don't want them in jail for life.
Well, you are right to read that and recognize that that would create some concern. But again, you're going to be looking at the evidence you have in front of you and whether or not you can prove that case. And if you can't, what is the outcome? That person is released from jail with only a fraction of the 15 years that we could have secured.
And that's what Haynes got. 15 years. The judge acknowledging the deal bypassed a 3rd strike, writing, quote, "The parties agree that justice is best served by this sentence." The last page, you'll see a pink sticky note.
Is justice best served? And that sickens me, and I want to ask these people if it was their loved one that he ran over, if they thought that 180 months was justice best served.
Do you think prosecutors made the right decision?
I do. Yes. The only way we get to assault 2 in this particular case is because of the shank. But the blows were either deflected or did not cause injury. The case would go away completely if the jury found that it was not a deadly weapon.
But after 22 years, this case is a matter of speculation. The judge has since passed. The prosecuting attorney can't be reached. And Haynes' defense counsel told us she has no recollection of the case, even though she filed to have her name removed from the record. But perhaps the most telling, now, decades later, the prison guard Haynes attacked declined an interview because it was so traumatic.
It sickens me. It really it disgusts me that they think that that was justice best served.
Now, it's like history's repeating itself. Another 90 days at Western State after Ruth's murder, forced medication, back to jail, where he once again refused the meds, and just like that.
Due to symptoms of a mental illness, he lacks the capacity to assist in his defense.
The cycle restarts.
This state is all about their rights, the criminal's rights. He doesn't want to medicate. You can't make him.
He will, of course, have due process rights.
I don't give a damn about his choices. The scales are not even in our justice system. 3 strikes needs to be 3 strikes.
And Haynes has been charged with murder, assault, and animal cruelty. A conviction on either the murder or assault charge would count as that 3rd strike. His 90 days at Western State will wrap in July, and at that point, we will learn once again whether he's able to stand trial. We have reached out to King County prosecutors. They told us they cannot comment on ongoing cases.